Breaking news, we have a preview of Monday 10 a.m.'s oral argument. Not just one oral argument, but 5 of them in 5 huge Second Amendment cases before the United States Court of Appeals in New York City for the Second Circuit. Let me break it down for you when we get back. Important information here. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the Bill of Rights and the Second Amendment. Okay, folks, I'm going to make this fast. I want to give you a quick preview of Monday morning. This is a very big morning. I'm going to give you the good news, the bad news, and the ugly news. Bottom line is this, 411. On Monday morning, starting at 10 a.m. New York City time, there will be 4 arguments in front of the Federal Court of Appeals for New York, which is the United States Court of Appeals for the Second Circuit. I'm quite familiar with this court. It will be in front of 3 judges, a 3-judge panel. That 3-judge panel will consist of Judge Dennis Jacobs, a senior judge who was appointed to the bench by George H.W. Bush, a very smart judge, a member of the Federalist Society, a law and order kind of conservative who's long time from New York City. Actually, I would say he's not a great judge on the Second Amendment historically because he's from New York City and has the view, in my opinion, this is my view, generally speaking, a law and order old-fashioned conservative like a Bill Bennett type tends not to be good on Second Amendment issues and historically has not ruled in our favor. But in fairness to Judge Jacobs, he has done so in the context before Nysurpa versus Bruin in a world where the right to keep and bear arms in New York consisted of really the privilege to have guns and not the right. So one does think that Judge Jacobs is someone that you could win over, but only time will tell. Historically, you would say his record is not great on guns, but again, that was all in a pre-Bruin world before the Supreme Court decided Nysurpa versus Bruin. The second judge on the panel is Judge Eunice Lee. She is a Joe Biden appointee. She's relatively recent. She's the only active judge on the Second Circuit panel on Monday. The other 2 judges are senior judges. Judge Lee is a former public defender. She's originally from Ohio. Obviously, being a pick to the federal bench by Joe Biden suggests that she won't be good on our issue, the Second Amendment. With that said, she's a longtime public defender, which means she's defended a lot of criminals. And, strangely enough, a lot of the people that are public defenders, people that have represented indigents, people that have represented minorities on the criminal defense side of things, see some of the abuses these gun control laws can do to people, especially when the gun control laws are, as you know, what are really malum prohibitum crimes, which means they're not malum in se. Malum in se means evil in and of itself, things like murder, rape, robbery, fraud, things that we all just intuitively understand are wrong. Malum prohibitum crimes, which is basically all of federal and all of state gun control laws, are really just crimes because the legislature says so, like jaywalking, having a gun that is not a sufficient number of inches long, et cetera, et cetera. This is malum prohibitum. So sometimes you get public defenders, potentially like a Judge Lee, who might be sympathetic to knocking out gun control law on the grounds that they are abused and misused laws applied against people that can least afford to defend themselves in our society. And the last one is Judge Gerald Lynch, obviously a guy who is problematic, a former, he's appointed to the federal bench by Barack Obama. He is a lifelong New Yorker. I would say another unlikely pick to vote for us on Second Amendment issues because a lifelong New Yorker who's a liberal is definitely not going to be good on guns. Both he and Judge Jacobs have issued anti-Second Amendment rulings, but in fairness to both of them, these were before Nysurpa versus Bruin was decided. With that said, I think this is overall not a good panel for us. I repeat, not a good panel for us in the Second Amendment community. That doesn't mean it's impossible to prevail on. I'm just saying that it's probably going to be an uphill battle. If I were the lawyers in the cases that I'm about to describe in 1 minute, the way I would probably handle the argument here is I would really try to emphasize professionally and civilly to this panel that you may like guns, you may hate guns, you may like the Second Amendment, you may not like the Second Amendment, but the reality is your hands are tied because the U.S. Supreme Court has told you in Nysurpa versus Bruin in June of 2022, this is what you must do as a quote-unquote inferior court. As you know, the words inferior court appear in the text of the United States Constitution, Article 3. Again, the Supreme Court is the Supreme Court, which makes them the numero uno court in America, and all the other courts created by Congress, including the Second Circuit Court of Appeals and the district courts, which are trial judges, all of those other courts are considered in Article 3 of the U.S. Constitution to be quote-unquote inferior courts. And I would politely argue that implicitly on Monday morning if I was arguing this case. Again, I don't think this is a great panel for the Second Amendment, and thus I would be trying to say you may not like the Second Amendment, but you have no duty but to follow the law as set forth by the text of the Second Amendment and the case law of the United States Supreme Court, and I would try to force them to do the right thing on the grounds that in their scope or job as inferior courts, they have no choice. That's how I would try to frame it, given this panel, which again, I don't think is a great panel for us. Now, there's 5 cases being argued starting at 10 a.m. on Monday morning. I'll put a link to down below of what I think is the audio feed. So if you want to listen to these arguments, you can hear them. Here are the 5 cases you need to know about Monday morning, 10 a.m. New York time. Number 1 is a Firearms Policy Coalition case, also a Second Amendment Foundation case called Christian versus Negrelli. This was decided by Judge Sinatra in the Western District of New York, that is in Buffalo, New York. This was a case involving the so-called private property default rule. Just to jog your memory, before Nysurper versus Bruin, if you had a carry permit in the state of New York, you could carry your gun basically everywhere in the state of New York. There were no so-called sensitive places, which, as you know, are government-mandated gun-free zones. Before the Supreme Court decided Nysurper versus Bruin, I did several videos warning everyone in America that where the anti-gunners were going to go after they got spanked was by talking about sensitive places and declaring everything a gun-free zone using the sensitive place so-called exception. And that is exactly what, of course, Kathy Hochul in New York did. They tried to declare all of New York a sensitive place, a gun-free zone. And one of the critical things, and this is a very important argument to watch at 10 a.m., in the Christian versus Negrelli case, because they're basically said in New York that up until Nysurper versus Bruin, if you had a carry permit, you could carry everywhere in New York. But after this decision, the state legislature of New York changed the default. And what I mean by this is now today, even if you have gone through the crazy process and paid the money and done all the nonsense that you need to do to get your carry permit from the state of New York or from the NYPD, okay? If you've done all of that, you've been fully vetted, and you've got your ID to carry your gun in the state of New York, you still have to get permission from any private property owner, whether it be a gas station, whether it be a supermarket, whether it be a convenience store, whether it be a deli, it doesn't matter, a restaurant, you have to get permission from the private property owner, either in writing, by virtue of a sign out front, or some other communication before you can carry a gun into that private place. And if you do not do though, even if you have your carry permit, if you go into a gas station where you have not received the permission, either by virtue of a sign that says guns are allowed or some other way with a form of an email or communication, if even with your carry permit, if you walk into that gas station without that express permission, you are committing a felony because of the law that was enacted after Nysurper versus Bruin in the legislature of New York. This is a case involving whether or not that's constitutional. That shifting of the default from you're allowed to carry a gun everywhere in New York unless it's a quote-unquote sensitive place specifically, to you're not allowed to carry a gun anywhere in New York unless you get specific permission from the private property owner. That default argument is the first case being argued, Christian versus Negrelli. Again, Second Amendment Foundation Firearms Policy Coalition case of Christian versus Negrelli. The second case being argued is a case called Hardaway versus Seaman. Hardaway versus Seaman is a very interesting case. This deals with places of worship under the Second Amendment. This is important because it's going to distinguish it from the third case I'm going to talk about. Again, the second case is Hardaway versus Negrelli. This is another case decided by the Western District of New York Judge Sinatra in Buffalo. This case specifically challenged whether or not, because New York State Legislature banned, just outright banned, as a quote-unquote sensitive place, government-mandated gun-free zone, all places of worship, no guns in places of worship, churches, synagogues, and the like, and basically was outright banned. This is a challenge saying this violates the Second Amendment, because if you go back to the text, history, and tradition of the Second Amendment, and specifically to the founding of the United States, not only is there no historical analog preventing you from being able to carry a gun, but also there's historical analogs telling you that if there's a danger from local Indian tribes and the like, you actually had an obligation to bring your gun to places of worship. Back then it was churches. So not only is there no historical analog that justifies a modern-day gun restriction saying no guns in places of worship, it actually works in reverse if you go back to the founding era history. Judge Sinatra in the Western District of Buffalo decided exactly that and ruled in our favor. But as you know, with respect to all 5 of these cases, the Second Circuit basically has ruled tentatively for administrative grounds in favor of the against the Second Amendment. So even though we won the Christian case and the Hardaway case in the lower courts, the Second Circuit Court of Appeals stayed those orders, allowing the anti-gun laws to remain in effect with respect to the Christian default property right position, and with respect to the Hardaway case, saying that you could not bring guns in places of worship. And those are the first two cases. Again, those are both Firearm Policy Coalition Second Amendment cases, right? Second Amendment Foundation cases, right off the top. The third case is an interesting case. It's called Spencer versus Negrelli. This is the third case being argued on Monday morning. This actually is a case being argued involving the First Amendment. As you know, the First Amendment has several protections, one of which is the protection from what's called the establishment of a national religion. That's the Establishment Clause. A related provision of the First Amendment is that you have the right to practice the religion, you have the free assembly, or you have the right to free exercise clause, the free exercise of one's religion. So basically, in the case of Spencer versus Negrelli, another decision by Judge Sinatra out of Buffalo that says that it not only does the places of worship ban violate the Second Amendment's right to keep and bear arms, it also violates the First Amendment's right to the free exercise of religion, because it discriminates against religion. Because if you think about it, what the judge said is that if you own a supermarket in the state of New York and you want to allow guns in, even under the default law that is arguably unconstitutional, you can put a big sign out front that says guns are allowed if you have your carry permit, and now you're allowed to have guns. In contrast, the way the New York State legislature wrote the law with respect to places of religion, places of worship, even if the minister or the pastor put a sign out front, guns are allowed, the state of New York law prevents that. So in a sense, the law discriminates against places of worship because they actually make it easier for people to bring guns into supermarkets and delis than into churches, because basically they said no guns in churches, period, full stop. In the case of Spencer versus Negrelli is this First Amendment challenge saying that, hey, you know, you're treating churches worse, and you're treating places of worship like it's synagogues worse than other places in New York, and thus it violates the First Amendment's right to the free exercise of religion. So that's really a First Amendment challenge. Again, that was another victory for the Second Amendment and First Amendment against the gun control law down in the lower courts, but the Second Circuit basically enjoined those and would not let those restrictions on the gun bans from taking effect. So basically, all the terrible gun laws remain in effect in the state of New York because of the Second Circuit Court of Appeals decision that basically stopped the enforcement of Judge Sinatra's decision in the Western District of New York, even though they were well-reasoned. The fourth case is the Ivan Antoniuk versus Negrelli case. This is the case in front of Judge Sotheby, I believe, in the Northern District of New York, out of Syracuse. Again, major victories for the Second Amendment in the lower court that the Second Amendment stopped in and would not allow to be enforced, which was most unfortunate. Antoniuk is the broadest case. I repeat, this is the broadest case, challenging the most aspects of the Concealed Carry Improvement Act, which is the name, euphemistically New York name, that's carry law after Nysurpa versus Bruin that made it very difficult to carry even with your permits. So Antoniuk is a challenge not only to the details of how you go about getting the permits, some of the requirements like social media account review and the such, but also about some of the issues involving so-called sensitive places. So Antoniuk is a very broad case. By the time we get to this fourth case of Antoniuk, I think we're going to have a much better sense of where the panel stands by virtue of their questions. But the Antoniuk case, again, this is a Gun Owners of America case. They've done a great job so far. That'll be very fascinating as to what happens in this fourth case. And the last case is really a gun industry case. I won't get into the details too much here. It is an important case. The case is Gazzola versus Hochul. In this case, involves some of the restrictions that have been applied to FFL's federal firearms licensees and gun industry type regulations arising under the Second Amendment and the like. And again, this is really an industry type case. So it's important to the Second Amendment, of course, but it's more specific to commercial interest, which is a little bit of a tougher argument, although it shouldn't be, but it might be a tougher argument because some of the language that we've seen in prior Supreme Court cases that say, we're not saying that you can't have economic regulations of the gun industry in the same way you have economic regulations of other industries dealing with commercial transactions. So I would imagine the Gazzola case may be a little bit tougher case on our behalf, although we hope they certainly win and win big as well. But because it's a commercial interest case, those can be a little bit trickier in the context of the Second Amendment, although they shouldn't be. They probably are, given everything that has been going on with Second Amendment jurisprudence. Okay, the last thing I want to remind you all, remember, the district courts in 4 of the 5 cases entered very favorable rulings in favor of the Second Amendment, and then the Second Circuit stepped up and enjoined. It says we're not going to let those district court rulings take effect, which meant, again, the anti-gun rules are still in effect in New York, which is most unfortunate that the Second Circuit did this. The reason why I want to remind you about something is that there was an appeal taken to the United States Supreme Court asking that the Second Circuit's anti-Second Amendment ruling that stopped the enforcement of the injunctions entered by the district courts, saying basically that the district court ruling should be allowed to go forward and the Second Circuit should get out of the way. And the Supreme Court, as a matter of administrative law, just said, we're going to defer to the Second Circuit Court of Appeals here. If they don't want these district court rulings to go into effect, we're going to defer to them. But what's significant about that, as you may recall, is that Justices Sam Alito and Clarence Thomas issued a statement that went along with that decision that said it's our understanding that the court is making this decision purely on administrative grounds, basically just saying we don't want there to be confusion in the state of New York while this appeal is being resolved. But we think, this is Justice Alito and Justice Thomas, we think that the district court decisions were well-reasoned and well thought out, and to the extent that there is a adverse ruling against their interest by the Second Circuit Court of Appeals, feel free to come on back and we can talk about the merits at some point down the road. I thought that was kind of an extraordinary statement from Justice Alito and Thomas, essentially encouraging the pro-Second Amendment plaintiffs to come on back to the Supreme Court if the Second Circuit doesn't follow NYSERPA versus Bruin properly. I think that is something that probably will weigh on the minds of this three-judge panel, which, again, I don't think is a great panel for us. But with that said, I think they are all earnest judges. And if they follow the law and do what they should do, we should do very well here and win. But again, I would say it's going to be a very close call as to what happens. And what's going to happen next is we're going to have oral arguments on Monday morning starting at 10 a.m. That'll go for probably about 2 to 3 hours. It'll be done around lunchtime. And at that point, the panel will recess and we'll probably work on writing their decisions. They will likely take several months. Maybe we'll get a ruling sometime this summer because the Court of Appeals usually takes several months to write major decisions, and this certainly will be a major decision. Okay, folks, I hope you learned a little bit something here about the 5 cases being argued Monday. And if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.